Good morning, everybody. I'm your host, the Supreme Litigant, and I am back again with another video. Y'all already know the routine. Before I begin, if y'all don't mind, please hit that subscription button, turn on that notification button also, and hit that like button. I really appreciate it. I'll give y'all a second to do that if you haven't already. All right, let's jump to it. So today, I'm going to be talking about this case in which I made a video on for y'all. Uh, This is the case in Arnold versus Kemp, in which a pro se litigant basically sued a bunch of public servants for failing to basically protect him. He's arguing that they have a constitutional duty to protect him, among other things. So I'll do a video on the facts of his complaint either to later today or tomorrow. But today I'm going to be doing videos on their response to his complaint. I think there's two responses to his complaint, and he did file a response in opposition to their motions to dismiss. So I'm going to be doing three videos today. If their video, I mean, if these motions to the two motions to dismiss, if they're not basically the same, then I'm going to do another video. And if they are basically the same, I'm not going to do another video because it's just going to be the same. They're just going to be arguing the same thing. So it'd just be pointless to do two videos. So I'm going to go ahead and get started. This is the case number right here if y'all wanted to follow it. It's filed in the United States District Court for the Northern District of Georgia, which is a territory of the United States, even though they don't probably own that land. Anyway, defendant, he sued the governor and the attorney general. So this is their response. Let me see. He actually just texted that noise that y'all just heard was a text message from the guy who's suing these people right now. Let me see what he's saying. Okay, cool. Okay. So he said he got something important to talk about. We'll talk about that later. But anyway, defendants, Governor Brian Kemp and Attorney General Chris Carr, by counsel, submit the brief in support of their motion to dismiss plaintiff's complaint, showing this court the following. The facts, I'm going to read y'all the facts on now this may not be 100% accurate because these people will lie. They'll misspell some words, they'll take out a word, they'll say you said this when you didn't say it. So you just got to be very careful. The way that if you really want to know the actual facts of DeAndre's complaint, then you need to go and read his actual complaint to know if these people are telling the truth. But anyway, I'm going to read this. Plaintiff DeAndre Arnold's allegations against Governor Kemp and Attorney General Carr are difficult to understand, but he appears to allege that in 2022 and 2023 he mailed sworn complaints to Governor Kemp and Attorney General Carr, informing them that Judge Brian Amiro, a non-party Superior Court judge, had allegedly committed a crime because he was going to falsely imprison plaintiff for failure to provide child support. Plaintiff claims that Governor Kemp and Attorney General Carr, upon receiving these complaints, should have investigated, arrested, or indicted Judge Amiro and other state officials and employees for conspiracy to commit false imprisonment. But neither Governor Kemp nor Attorney General Carr did any of these things. Plaintiff claims that because of their inaction, they failed to protect him and provide him with protections with protection services from state-created danger. So his argument seems like it has merit to me. Arnold's argument. It seems like he has a good chance on this argument so far. I haven't read his complaint yet. Plaintiff has asserted 5 counts against Governor Kemp and Attorney General Carr. Count 1 is for declaratory relief. Count 2 is for a breach of contract based on their alleged failure to uphold their end of a social contract to provide protection of the laws of the plaintiff. He's talking about the Constitution in there. He's right. It's a social contract. He's right. Count 3 is a substantive due process claim based on their alleged failure to protect plaintiff under the Shaney versus Winnebago which is basically the case that I cited. And if you're going to if you're going to watch my video where it says something about why the police in Texas or something like that did nothing, in that video, I'm telling you that as a matter of law, they have no constitutional duty to protect you from danger. But there are a few exceptions to that. Whether or not, if those exceptions applied in that situation, I don't know. Count 4 is a First Amendment claim in which plaintiff claims that Governor Kemp and Attorney General Carr violated his right to redress of grievances. So basically, it seems like he's saying their inaction constituted. I don't know. I might be wrong, so I'm not going to say that. But let's go to count 5. Count 5 is for conspiracy under 42 Section 1983. Count 6 is for an intentional infliction of emotional distress. Count 7 is for attorney's fees. This court should dismiss plaintiff's claims against Governor Kemp and Attorney General Carr for the reasons set forth below. Now they're going to argue immunity. The 11th Amendment bars actions against a state, its agencies, and its officials absent a waiver by the state or a valid congressional override when the state is the real party in interest or when a monetary recovery would be paid from state funds. Let's see. As the Supreme Court has explained, the ultimate guarantee of the 11th Amendment is that non-consenting states may not be sued by private individuals in federal court. So let me tell y'all something right now. The 11th Amendment does not say that states are immune. What the 11th Amendment does is the sovereign people of the United States of America have taken away the authority of federal courts to adjudicate cases in which a citizen sues a state. That's all it did. It just took away their authority to decide the case. That's it. It does not say that they are sovereign because they're not sovereign. A waiver of 11th Amendment immunity must specifically permit suits in federal court. For a state statute or constitutional provision, what they're doing is right now, y'all, this is how you litigate a case. Let me explain this to y'all, but this is how you litigate a case. So they're arguing the law in support of why they're making this motion to dismiss. That's what they're doing. And they're citing a whole bunch of case law. Notice that this is in Georgia. All U.S. Court of Appeals, all United States District Court appeals in Florida, Georgia, and Alabama go to the 11th Circuit. That's why you're going to see either some U.S. District Court Florida cases in here, some U.S. District Court Georgia cases in here, some U.S. District Court Alabama cases in here, or you'll see the 11th Circuit, or you'll see United States Supreme Court decisions in here. It's very rare that you would see other U.S. District Court cases in here that I didn't mention. Let's see. The 11th Circuit. Where was it? For a state statute or constitutional provision to constitute a waiver of 11th Amendment immunity, it must specify the state's intention to subject itself to suit in federal court. Notice they're talking about consent. Consent. The 11th Circuit has made clear that the state of Georgia has not waived its 11th Amendment immunity from suit in federal court for breach of contract claims. Let me say this. The state of Georgia is a corporation. So what y'all need to understand, y'all have to distinguish Georgia from state of Georgia. Okay? The state of Georgia is a corporation for Georgia. It does business with other corporations on behalf of Georgia. It's no different than the state of Florida. The state of Florida is different from Florida. Florida collectively is the people in Florida. The state of Florida is a corporation that is doing business on behalf of the people in Florida. It's a fucking corporation. That's why it has a DUNS number and an EIN number. It is a corporation. That's what it is. These corporations, in my opinion, are not sovereign and they are not immune. The 11th Amendment does not say that these states are sovereign. It does not say that. Anyway, let's see. To the contrary, well, let me rephrase it. It doesn't say that expressly or implicitly because they're not sovereign. To the contrary, the Georgia Constitution expressly retains the state's 11th Amendment immunity for such claims. Specifically, let me see. Yeah, they're talking about OCGA section 52(1)B specifically says that venue with respect to any such claim for breach of contract shall be proper in the Superior Court of Fulton County, Georgia, because 11th Amendment immunity has not been waived for breach of contract claims against the state that are filed in federal court. This court lacks jurisdiction over plaintiff's breach of contract claim and so it must be dismissed. I can't wait to see his response because he filed a response to this, so I can't wait to see his response. Plaintiff's substantive due process claims fail as a matter of law. The due process clause provides that no state shall deprive any person of life, liberty, or property without due process of law. The clause serves as a limitation on the state's power to act, not as a guarantee of certain minimum levels of safety and security. Consequently, the Supreme Court has repeatedly recognized that there is generally no affirmative right of governmental aid. Although there are limited circumstances in which the Constitution does impose upon the state the affirmative duties of care and protection, these duties apply only to involuntarily committed mental patients, prisoners, and involuntarily placed foster children. So those are the exceptions, if I'm not mistaken. It seems like those are the exceptions. Those cases stand for the proposition that when the state has taken a person into custody, the Constitution imposes upon the state a corresponding duty. Yeah, they're talking about, those are the exceptions that I just read, y'all. The Constitution imposes upon the state a corresponding duty to assume some responsibility for his safety and general well-being. Thus, it is well settled that only custodial relationships automatically give rise to a governmental duty to protect persons from harm by third parties. There are no allegations in plaintiff's complaint indicating that he was ever in the custody of the state of Georgia. As a result, Governor Kemp and Attorney General Carr can be held liable under the due process clause only if their alleged acts or omissions were arbitrarily or conscience shocking in the constitutional sense. Let's see. The allegations in plaintiff's complaint fail to meet this standard. This is nothing. There is nothing conscience shocking about Governor Kemp and Attorney General's alleged refusal to arrest or prosecute or refer for prosecution a judge merely for enforcing a child support order against plaintiff. If plaintiff disagreed with judge's decision, the proper resource was to file an appeal, not to sue the governor and the Attorney General of Georgia. Plaintiff's First Amendment claims fail as a matter of law. To survive a motion to dismiss, a complaint must contain enough facts to state a claim for relief that is plausible on its face. Remember, I told y'all it's always about the facts. The facts are the elements that you need. The facts, what the judge will do with the facts, as I've said numerous times, is they're going to take the facts and apply the relevant case law to the facts to determine if the facts are sufficient to justify your lawsuit. They're supposed to do that on the criminal side. When a police officer file criminal charges against you, your person, they do the same exact thing on the criminal side. That's what they're supposed to do. That's why they have to give you the facts, because if they don't, they violate due process because you can't properly litigate the lawsuit against you. And it's kind of like a violation of double jeopardy. They need to do that because it's preventing you from being prosecuted from the same set of facts. Double jeopardy. And on the civil side, they call it, I think it's res judicata on the civil side. And on the criminal side, it's called double jeopardy. It's pretty much the same shit, though. A pleading that establishes no more than the possibility of unlawful conduct does not state a claim for relief. The complaint must contain factual enhancement to support its assertion of unlawful conduct and may not rely on conclusory allegations. You can't make conclusions, y'all. Remember when I told y'all that? You cannot make conclusions, and neither can they. They can't do it on the civil side, and you damn sure can't do it on the criminal side, but they do it all the time. You cannot make conclusions. It's a violation of due process. When they make conclusions against you in a criminal case, you motion to dismiss because the complaint is devoid of the prerequisite elements of the offense. It's vague, it's conclusory, and it's legally insufficient as a matter of law. That's what you say. They're going to know exactly what you're talking about. They might act like they don't know, but they're going to know exactly what the hell you're talking about. The allegations in plaintiff's complaint fail to state a First Amendment claim that is plausible on its face. Plaintiff contends that Governor Kemp and Attorney General Carr violated his right to petition for redress of grievances. But there are no allegations in the complaint indicating that Governor Kemp and Attorney General interfered with or barred plaintiff from filing any complaints, petitions, or other court documents. Now, I'm going to say this. I talked to DeAndre yesterday. I had him on the show yesterday. Me and him was talking. We talked for probably almost an hour, close to an hour yesterday on the show. He does not strike me as as a litigant who does not do his research before he litigates, before he files a lawsuit. He doesn't strike me as that. I think he knows what he's doing. I'll be certain that he knows what he's doing once I read his complaint. But based on the conversation that I had with him, he seems to know what he's doing. Plaintiff's conspiracy claim fails as a matter of law. The core of conspiracy claim is an agreement between the parties. Well, shit, that can be an expressed agreement or an implied agreement. It doesn't matter. Thus, where the plaintiff fails to allege an agreement, the pleading is deficient and subject to dismissal. Vague and conclusory allegations of conspiracy are not sufficient to withstand a motion to dismiss. Conspiracy must instead be pled with particularity. I can't even get the word out. Particularity. Here, plaintiff has failed to allege facts showing the existence of an agreement between Governor Kemp and Attorney General or anyone to violate his rights. This court should accordingly dismiss plaintiff's conspiracy claim for failure to state a claim. Qualified immunity bars plaintiff's civil rights claims. Let's see. Now, remember when I told you how to beat qualified immunity? To beat qualified immunity, you have to do this in the complaint. Okay? You have to plead facts that show a clearly established, constitutionally protected right of which a reasonable officer would have known has been violated. That's all you have to do. Tell the story about what happened. Make sure the facts show that a clearly established, constitutionally protected right has been violated. That's all you have to do. If you can do that, they're not going to get immunity, at least at that stage. They're going to hold off and they're going to go to discovery. They're going to 9 times out of 10 it'll likely go to discovery, and after discovery, then they'll revisit the qualified immunity claim or something like that to see if the facts warrant or don't warrant them getting immunity. Qualified immunity. Qualified immunity protects governmental defendants sued in their individual capacity so long as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. For qualified immunity to apply, defendants must show that they were acting within the scope of their discretionary authority when the allegedly wrongful acts occurred. They are not authorized in their public capacity to violate your rights. So when they do so, they're no longer acting in their public capacity. They are acting in their private capacity. So if the Constitution imposes upon them a duty to protect you, then they have to, as a matter of law. The burden then shifts to the plaintiff to establish that qualified immunity is not appropriate. To carry that burden, the plaintiff must show that the right asserted was clearly established. The salient question there is whether the state of the law at the time of the incident gave the defendants fair and clear warning that their conduct was unlawful. The complaint makes it clear that Governor Kemp and Attorney General were acting in their discretionary authority, within their discretionary authority. The burden therefore falls to the plaintiff to show that qualified immunity doesn't apply. He cannot meet this burden because, as explained in the previous sections, no constitutional violation is shown by the allegations of the complaint. Qualified immunity also bars the claims because pre-existing precedent does not clearly establish any constitutional violation in this case. Qualified immunity therefore bars plaintiffs' civil rights claims against Governor Kemp and Attorney General Carr, and they should be dismissed for this additional reason. Sovereign immunity bars plaintiffs' IIED claim. I wonder what IIED, what does that mean? Let's see what that means. The Georgia Tort Claims Act governs plaintiffs' tort claims for IIED. The act expressly preserves the state's sovereign immunity where, as here, a plaintiff sues the state in tort in federal court. The state does not waive any immunity with respect to the actions brought in the courts of the United States. Y'all paying attention to that? Do y'all see what this shit says? In courts of the United States. Those are federal courts of the United States. When they say courts of the United States, they're talking about a foreign they're talking about a foreign government, man. This shit is starting to become so clear to me now. It's just crazy. Thus, because plaintiff has brought this state law tort claim in federal court, it is barred by sovereign immunity and must be dismissed. And they state the the reason right there. Here's a footnote. Let's see what this footnote says. Even if plaintiff has brought his IIED claim in state court, it would still fail as a matter of law because he failed to comply with the ante litem notice and service provisions of the Georgia Tort Claims Act, blah, 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 and he failed to sue the correct defendants. That's what they're arguing. Let's see. Concluding that plaintiff's state law claims were barred by sovereign immunity because the act specifically preserves the state's sovereign immunity from suit from torts filed in federal courts. Conclusion, blah, blah, blah. For these reasons stated herein, Governor Kemp and Attorney General Carr asked that the complaint and claims asserted against them be dismissed. So that is the complaint. I mean, that is the motion to dismiss. That's the first motion. So what I'm gonna do now, because I'm on Pacer right now, so I'm gonna go back into the docket, and these are all of the documents that were filed in this case. I think I just read y'all the first motion to dismiss. So these are a lot of summons. Was this clerk certified mailing order? Return of service executed, notice of change, a pro se address. So I think that one was this one that I just read. So let's go and order waiver of service motion to stay. I'm going to go and read the second one. And then this is his response in opposition. I'm going to read that one after I read this one. 16 pages, brief and support. We'll see. It might be the same thing, y'all. But I don't know, because I think he sued some judges too, so they're probably going to be claiming absolute or aka judicial immunity in this. So we'll see. Let's see how much time. I'm on 24 minutes right now. So defendant Tabitha Cooper's motion to dismiss. Complaint 16. Where are the judges at? Let me see who are. Well, this is only one. So I think what is this? Let's get to the motion. Is a clerk with the Georgia Court of Appeals. So she's a clerk. Well, I'll read this. Some people that I have questions about clerks too. Clerks, they are performing ministerial duties, statutory duties, so to speak. So they sometimes they have discretion if the statute gives them discretion, and sometimes they don't have discretion because the statute doesn't give them discretion. So I'm gonna read this and see what he's talking about. But I'm gonna do that in another video because I don't want to make this video too long. So I'll do another video. Um, so I'm gonna end this video, and the next video is gonna be based on this one. Supreme Litigant is out. I'll be right back, y'all, with another video.